If an attorney makes a critical mistake in civil litigation, what recourse does a client have? Can clients ask a court to set aside a final judgment because their attorneys did a bad job? Or is the client's remedy instead a malpractice suit against their attorneys? We explore those questions in Choice Hotels International Incorporated versus Grover. Choice Hotels International sued SBQI Incorporated in federal district court for breach of a franchise agreement. It also sued several of SBQI's managers and investors, including Anuj Grover. One of the individual defendants, Tarranpaul Chawla, was an attorney. He originally represented the defendants. His representation was inadequate and resulted in their default. Grover and several other investors, who we'll collectively refer to as the investors, asked Chawla to find new counsel. Chawla advised that attorney Elton Johnson would appear and represent their interests. Johnson took some steps to litigate the matter, but his representation was also inadequate. For example, he didn't move to set aside the default, nor did he respond to discovery. He didn't provide updates to the investors, nor did he return their phone calls. Ultimately, the district court assessed Choice Hotels damages at approximately $430,000 and entered final judgment in that amount. The investors then retained new counsel and moved to set aside the court's judgment pursuant to Federal Rule of Civil Procedure 60B. The investors were only entitled to relief if they could establish extraordinary circumstances that justified setting the judgment aside. The district court found that they couldn't and denied their motion. The investors appealed to the Seventh Circuit.